In the previous lecture, Bobby spoke about cyber defense, the defensive side of cybersecurity law, or how can law be used to promote stronger defense against malicious activity in cyberspace. Now we're going to focus on the other side of the coin, sometimes thought of as offensive activities, or at least activities in which the US government, maybe some other governments or other actors, but we're going to focus especially on the US government maybe trying to break into digital systems. As Bobby goes through his presentation, and again, I welcome questions through the Q&A function, which will work into the conversation. Here are a couple things to think about. One is often the kinds of activities that we're talking about here, government breaking into digital systems, is pretty invisible to the public. It lacks easy visibility or easy observability. And sometimes there are real security imperatives or intelligence imperatives behind that invisibility. But that poses some challenges for accountability. We want to hold the government accountable, government officials accountable for what they're doing. And it may also cause some problems for diplomacy. So how does the invisibility of these actions limit what we can do with law? The second question is a big one running through a lot of what Bobby's going to talk about, which is what's really so new here? And are there good analogies to other more traditional government activities? So for example, and for thinking about law and legal regulation, is cyber espionage really just the same thing as other traditional types of espionage, or is it meaningfully different in some way, and why? Or if the Defense Department engages in cyber operations to cause an adversary's military systems to malfunction, is it right to analogize that to the use of physical military force to accomplish the same thing? Those are just a couple of questions to provoke our thinking, and I'll turn it over to Bobby.
I'm going to quickly run through the same similar opening slides and reminding everybody, and keeping with what Matt just said, that we've just spent a lot of time talking about advancing the security mission piece of cybersecurity, and now we're flipping over and looking at the circumstances in which the goal of society, maybe certainly the goal of the U.S. government for sure, is in some cases to pave the way for actually affirmatively engaging in unauthorized access or excessive access to somebody else's system, and thus here we are in our roadmap. We're going to look at these things. Under the general heading of exceptions to the general goal of promoting defense, exceptions that are existing because of overriding or competing government interests of at least equal stature, we're going to talk about law enforcement and law enforcement hacking. We'll talk about the nation's spies engaging in hacking to advance espionage. We'll talk about what the military does in relation to armed conflict, and then purposefully saving the best and most interesting category for last. We'll talk about statecraft that takes place below the level of armed conflict, whether it's conducted covertly or otherwise. Some people like to call this gray zone competition. It's often what journalists and other commentators are really talking about when they casually throw around the phrase cyber war or cyber warfare. Usually we do not actually mean warfare. We mean something else, and category D there is where we'll come to grips with how at least our legal system and institutions and policy frameworks try to both enable and constrain it. Because remember, the name of the game across every one of these different tools we've been examining in this webinar is to ultimately understand what is it that we're trying to balance by way of enabling and constraining certain activities, and how law is used for that. All right, law enforcement first. Why does the government need to hack to solve crimes? Why does FBI in particular need this capacity? Why might local law enforcement need this capacity? And the answer is fairly simple. This is not a complicated area. It's because so much important evidence has migrated into places in the cyber domain that are protected by technical, especially technical means of limiting access. And as more and more evidence of crime has migrated into such spaces as a result of technological change, the imperative of having some way to get that information, well, it's the same imperative that always explains why we have law enforcement and what the purpose of law enforcement is. And it just takes on a special resonance insofar as the technical means needed to get access to that needed information involves breaking encryption or breaking any other sort of technical constraint that might have complicated, perhaps even very unwelcome spillover effects on society's other interests. And I don't want to hide the ball here, so let me just come right out straightforwardly describe the tension I'm trying to describe. If you only cared about law enforcement, then you would have only a focus on finding ways, technical if needed, to overcome whatever it is that is preventing the government from accessing otherwise lawfully available information. If someone has encrypted a device or in some other way taking advantage of encryption to shield the privacy of their communications and their stored information, if you only care about law enforcement, yeah, do whatever you need to do to figure out how to get around that, sure. The problem is that some of the things one might do to get around that, depending on what the solution is, might have spillover implications because that same technology, the same defenses that are being overcome also protect the much larger and widespread and universally relevant category of protection for all of us and all of our information and data. So we're met with one of those great tensions between hugely important societal interests. Society has an interest in law enforcement. Society has an interest in protecting the privacy of our personal data, our commercial data, and so forth. These things can be in tension in this space. Now, notice that this isn't specific to cyber crime. It could be any crime. It could be a murder or rape or any other number of horrific crimes or run-of-the-mill crimes where evidence of what happened or who else might have been involved might be stored or potentially might be expected to be stored on a device that has an encryption barrier that maybe the person who owns the device is dead and there's no way to know what their password was, or they're just refusing to cooperate. Or it could be cybercrime. It could be there's an epidemic of horrific child abuse, child pornography type crimes and other sexual abuse crimes that take place and circulate primarily and almost entirely these days, though not exclusively, in the cyber domain. And there are all sorts of black market illegal sales activities for all sorts of nefarious things. And that also can take place only online. In both cases, therefore, whether it's stored information about who's communicating and sharing information in the cloud, as it were, or if it's on devices that are available physically, but not technologically because of the password, encryption in particular can stand in the way of this. And a few years ago, we began to hear rumblings of law enforcement anxiety about this phenomenon, particularly focused, though not actually limited to, but really focused on phones. So if your phone is encrypted and the government has a warrant to access the contents of your phone, or otherwise it's lawfully allowed to do it, but as a practical matter, they simply don't have the capacity to do it without your cooperation. The idea is that they were authorized to access it, but going dark as the amount of devices and other scenarios where encryption was available and in use was beginning to expand. Now, you might think, if you're not familiar with the so-called going dark debate, that this seems like not that big of an issue, because why not just go to the vendor that created the hardware, or if relevant, go to the software vendor and find a way to have them, decrypt it, provide you the content. And in fact, there is a fair amount of that possibility out there. It's important to bear in mind, take iPhones with iCloud storage. There's a lot of information that may be technologically beyond the government's reach or anyone else's reach, including Apple itself, that may actually be perfectly available with the right process through the iCloud storage, but not always, and increasingly less often. And so the question arises, as a matter of policy, do we want the government to be able to hack around that. If not, that's going to increase the pressure, politically speaking, that already is getting fairly strong on having Congress pass legislation to compel, either with a lot of detail or just a naked compulsory order to find some way to do it, compel the vendors, the companies that make the phones like Apple or the other devices, to compel them to have the ability to decrypt when presented with a lawful warrant, a court-issued warrant. These are the stakes in the debate. Those who are coming at this debate more from the privacy perspective decry these efforts towards possibly compelling the companies to establish the ability to decrypt a customer or client's information without their knowledge or awareness, as creating a vulnerability that makes all of us vulnerable, everyone vulnerable, a vulnerability that however much effort is made to shield others from knowing how it works, nonetheless, you've created a pathway, and sooner or later someone will figure out how to exploit it themselves. And you really get this sort of immovable object versus irresistible force kind of dynamic, where all of us really do depend on this privacy. Our commercial life increasingly depends on it, certainly our personal lives. And yet the government's need for access to this information seems to grow all the time. Just the other day, I don't think the text is available, but a few days ago, Senator Graham with other co-sponsors introduced a bill in the Senate that I gather, not having been able to read the text, but I gather from the press statements, is more or less simply a directive to tech companies that if they want to do business in the United States, they've got to, one way or the other, come up with the technological means to effectively backdoor these encrypted devices or otherwise when presented with a court order obtained through the normal law enforcement warrant process. I'd be curious to see whether they extend that to other authorities as well, but surely it at least encompasses warrants. The pressure to enact a statute like that is less, the policy case for having a statute like that is less if there is a reasonably reliable alternative pathway where no such broad vulnerability is intentionally created by the companies, and instead law enforcement can turn either to its own engineers or to private sector engineers and hack their way into the devices anyways, or hack the way into the spaces online that they need to get to anyway. So that's where the going dark debate, which you're very likely in the next couple of months going to hear a great deal about in Congress, if you've not been following it already, it intersects with this question of lawful hacking. Hacking is the safety valve, and it's increasingly what the FBI and others have done. Now, as I emphasized, FBI in particular has its own very talented engineers. It's not the most scalable capacity. There's only so much bandwidth that capacity has, but they can acquire and develop their own capabilities for exploiting vulnerabilities in devices. Or, as the next slide illustrates, they could turn to what some deride as the insecurity industry. That is, private sector companies, both in the United States and around the globe, the business of which is to identify vulnerabilities, write exploits that take advantage of them, and then sell them, perhaps even as a service that they will implement for you, to customers. And the sort of the relatively white hat side of the insecurity industry is primarily or exclusively focused on selling to, let's say, US government entities or Western government entities, or other rule of law nation government entities. And then there's a spectrum that runs all the way into the dark web and the black market. And then interesting points on the spectrum in between, where you have entities that style themselves as selling their services really only to rule of law open societies. But in practice, you find that they sell to governments that then use their services to do things like going after journalists, going after protesters, civil rights or human rights advocates, et cetera. So the insecurity industry has a wide spectrum of actors, some more benign than others. And the question arises whether their activities should be legal at all. I have the particular images up here that I do because Apple is currently suing Corellium for what amounts to sort of a copyright IP type of claim, where Corellium's in the business of figuring out how to circumvent the encryption and other protections on iPhones, which is a critical capacity that law enforcement in the United States and elsewhere, I assume, is purchasing. And it's interesting to ponder that. So if Corellium, if it's really a civil violation for Corellium to engage in that, and maybe the courts will say it is, maybe they won't, then is it okay for FBI's own engineers to do this? And anyways, if Corellium and others like it go out of business, what then does that say about the mounting pressure on the FBI to find other means? If they don't have the hacking option, will this ramp up pressure on Congress to create a legislative mandate for a backdoor instead? I've also got the image of the Facebook, WhatsApp clash with NSO Group, a very famous or infamous, depending on your perspective, Israeli firm that's cited as a marquee example of a sometimes good guy, sometimes bad guy type of player in the insecurity industry. And I don't know what the truth of what they do or don't do is. I just know that there's a lot of grave concern about what has been done, whether they understood it was going to happen or not, by their clients, including in particular the Saudis. So a lot of serious tensions going on in this space.
Bobby, can I jump in there with a question then? Because you were talking about the hacking industry, government's sort of use of lawful hacking. It seems like a closely related issue that we could talk about here is an ongoing debate about the so-called hacking back. I'd say the argument usually goes like this. Private industry is under constant assault from cyber attackers, and it can engage in some level of defense, and it can call on the government for some help in that, but it's limited in what it can do and what the government can do. Wouldn't it perhaps make sense to allow companies, private actors, to hack back, to engage in their own, let's call it offensive, or sometimes it's actively defensive measures to go back at the digital systems, go back at the computers that are being used to attack them, whether it's for criminal purposes, espionage purposes, and so on. I say they're shackled currently because of some laws that you talked about in the previous lecture. Could you talk a bit about what the barriers are to that kind of hacking back, and what you see as the merits of perhaps legal reform that would allow companies to engage in more active defense or their own hacking back activities?
I'm so glad you brought this up, because this may be one of the most interesting areas at the intersection of law and policy and cybersecurity. So here's the fundamental obstacle. Let's have a hypothetical company in mind. So company X has valuable data. Let's say they're working on a vaccine for COVID-19, and they find, as indeed would be the case, because apparently a lot of this is going on, somebody's been hacking into their system. Now maybe it's China, maybe it's a ransomware crew that's just trying to figure out how to hold them up. Who knows? But somebody's getting in there, and then at a certain point, they're exfiltrating data, really valuable data. If this were happening in the physical world, and let's say I'm in my kitchen and I notice the garage is open, and I can detect using my eyes that someone is in my garage and checking out my bike, and bikes are kind of scarce right now, and he's found the good one. He gets on it and starts riding off. What are my options in the physical world? I can chase after the person, and especially if I'm still on my property, and depending on what state I'm in, there might be a lot of legal leeway on my property, in my system, to take action to keep my bike and to, let's just say, stop this person from stealing it. On the other hand, let's say discretion's the better part of valor, and I just watch, and I said, I'm just going to follow this guy. So I grab the other bike, and from a distance I watch, and dang if it's not my neighbor stealing my bike. And he pulls into his driveway 3 doors down, and sorry, Bill, if you're listening, I'm not really accusing you of a crime. So he goes in there, and I see him. Am I supposed to then go in his house, sneak in there, navigate laterally through his system and then repatriate my goods? No, of course not. I'm supposed to call the cops because we understand in the physical world, they accept in sort of stand your ground, protect your home, stay in your own system types of scenarios. We need to minimize the amount of private vigilantism in our society, lest we have too much violence spilling out in the streets, mistake, etc. And we have created the apparatus of law enforcement in no small part to fill that gap. And it'll work because I am quite confident that if I witness my neighbor stealing my bike, and I can attribute that to him effectively, and I know the cops will take a call about a stolen bike eventually. It might not be their first thing, but they'll show up and they'll go in there, and I have every confidence I will get my bike back. But what if it wasn't like that? What if the moment he slipped out of my driveway, that was it? And it wasn't my bike, it was my whole bank account. Or to come back to our company with its IP on COVID-19 vaccines, what if that's what it is? And there's no real way either, let's imagine, to call that 911 number in this digital context and effectively have someone showing up within minutes or even hours or even days. But rather, it's not even quite clear who you call all the time. And there's a bewildering forest of entities who themselves aren't entirely sure whether your particular fact pattern is worthy of their attention. And anyways, it turns out the person stealing your bike, as it were, it's a foreign government. And also, once it's out, it's too late, that there is no repatriating it because it's an expiring, perishable thing in that sense. All these are reasons why the analogy breaks down, at least often, when it comes to cyber crime or cyber espionage for that matter. And you get people saying, in advancing the argument, as a matter of policy, we need to have at least some actors some way to defend themselves because they're the only ones who can act quickly enough, and they're the ones in the best position to actually execute this. The government can't supply the law enforcement 911 type response in this setting that we need it to. The reason you need potentially legal change to make that possible is that if what we're talking about is leaving your own system to go into anyone else's network, to chase after the exfiltrated data, or to go after the command and control server that's causing the problem to you, which by the way, could also just be like, it could be DDoS, a distributed denial of service attack, for example. You're talking now about gaining unauthorized access to someone else's system. And by the way, it's probably not even going to be the attacker's own system because very likely it's a third-party system that's been compromised by the attacker to use as the staging server, as the storage point, etc. In other words, you're contemplating, or we're talking about here, the victim itself violating the Computer Fraud and Abuse Act. That is a fundamental obstacle. If you're going to gain unauthorized access to someone else's system in order to exfiltrate information or to take some action that will affect the operations of that system, then that is on its face clearly a violation of federal law. Now, the same is not true for what you do within your own system to protect yourself. If you're staying within your own system, that's different. Now, we can imagine edge cases, though, where you take an action where your affirmative role takes place within your own system, but the effect ends up being felt elsewhere. So the digital equivalent of a die pack in a bag of money being stolen from a bank that leaves the bank and then explodes later, you can have versions of that digitally. You can put effectively malware that is designed to achieve certain effects in files that you think are likely to be stolen should you suffer a breach. And later on, when opened and the executable file is opened later on, something happens downrange in someone else's system. There's an interesting debate about whether, does that violate the Computer Fraud and Abuse Act too? There's uncertainty on that point. So step back for a second. What have we got here? You have a spectrum of clarity where it's clear you can defend normally within your own system. It's clear it's illegal to go into someone else's system to cause effects there. And then there's this very gray area in between about the sorts of traps you might leave within your own system that will have effect outside your own system. And the hackback debate is about whether we should modify the Computer Fraud and Abuse Act in some way to pave the way, legally speaking, for some further amount of activity on that spectrum I just described. Tom Graves, a representative in Georgia, has a couple of times put out their draft legislation in a really interesting and useful exercise to see what would it look like, what hard questions would arise It hasn't gone anywhere yet. Maybe someday it will. DOJ doesn't want this sort of thing out there because A, they view it as the job of law enforcement. They're just generally going to be against anything that smacks of vigilantism. B, there's a concern that what may, to the omniscient perspective, be a victim hacking back into a compromised third-party server to get at the attacker will look to the third-party server's owner perhaps like an attack on it, which then warrants them hacking back against the original victim, and so on and so forth. It's the classic problem of a vigilante armed response in the street where latecomers to the party or people with imperfect information, they're not going to know who's the good guy, who's the bad guy here. So there are those problems. There's problems of how it's going to be if the hack actually turns out to involve the, I don't know, Ministry for State Security in China, and how are they going to respond? Or if it's the GRU in Russia, how are they going to respond when the American bank starts hacking back? There's an escalation risk and a loss of federal government control over the calibration of the response that, at least in some circumstances, can be really scary. In short, this is a truly wicked problem, but also a fascinating one. And the fact remains that as long as it is not realistic to have a 911 type solution for the private sector when they are in the midst of an ongoing breach, there's going to be a lot of temptation to perhaps find someone who will quietly help you despite the legal risks, which, that'll depend on the risk appetite of the company in question. You hear rumors about some American companies having gone down this pathway. And in the meantime, just continuing policy pressure to enact some form of at least limited legislative intervention. Okay, so going back to our slide. So we were talking about law enforcement, and then we detoured into self-help law enforcement there. Both of those are scenarios where with formal law enforcement, already there's a significant amount of activity that involves what you might as well describe as offensive hacking that does go on under color of otherwise lawful investigative authority, to be sure. And you have a whole collateral private industry supporting that activity, but also potentially being used for much more nefarious things. And then you have this possibility of more of a self-help realm that's not currently legal, but might one day become so. Well, let's go back to the government. We'll stay with the government from now on. We mentioned in our earlier discussion in the first lecture, NSA and GCHQ, and for that matter, the Chinese Ministry of State Security, Russia's GRU. These are entities that are very much in the business of espionage. And long before there was a lot of hacking, there was always a lot of espionage. And so no surprise that just as a lot of the evidence of crime in a lot of our commercial life and a lot of our personal lives have all, indeed this webinar, have all migrated into the online space, so too have all the objects for espionage. You cannot reasonably pursue your national espionage mission, whatever it is seeking to maximize these days, by being confined to traditional means such as human intelligence, interception of radio signals, etc. Hacking is central and indispensable to 21st century espionage. And there's just no two ways about that. So I think the importance of the cyber domain to espionage is clear enough. Let's put an example on the board that kind of reverses the lens here. One of what appears to be one of the greater Chinese espionage successes of recent years was the successful breach of the U.S. Office of Personnel Management, which yielded an amazing treasure trove of security clearance background check files and other personnel files, just incredibly rich with information about all sorts of people, but everybody you might want to know. Everybody, that is, except for those whose security checks were performed by CIA. I could go on and on about how that also was to an indirect degree compromised by this breach, but this was a huge deal. And when former DNI Jim Clapper was talking about this one time publicly, he was criticized for saying at one point, hats off to the Chinese for this. But it was unfair to criticize him for that. To say hats off to the Chinese doesn't mean that we're happy they did this. it means that we do this sort of thing too, and that as a professional, a professional evaluation of the utility and quality of that operation, wow, they pulled off a really great operation. One hopes that we are able to pull off similar operations directed at Russia, China, other adversaries. And indeed, I suspect we probably are pretty good at that sort of thing. Point being, our system, for better or worse, not everyone likes this, but for better or worse, our system very much endorses and expects, makes legal, and funds to the nth degree the ability of NSA in particular to engage in hacking for foreign intelligence collection purposes. And nothing could be more really ordinary from an intelligence collection perspective than that. What's interesting is where we might draw the line if it were entirely up to the United States in the realm of things that would count as, well, we respect it even when we try to fight it off when the other guys do it. What counts really as espionage that seems sort of normatively appropriate, even though we try to defeat it and we engage in it ourselves? The United States wants to draw a line that reflects what I said earlier, was that terribly important private-public barrier, which is to say we do not steal foreign secrets in order to aid private American companies. We steal them for the US government's own purposes and only for the US government's own purposes, whether that's to advance understanding vis-a-vis national defense, pandemic stuff, trade negotiations, whatever it might be, but it's for the US government. And we draw that line because in our society, we have that sharp distinction. It gets interesting because, of course, other countries don't draw the same distinction. China, most famously, doesn't draw that distinction. They don't accept that distinction, and they don't agree that the fact that we draw that distinction means that they have to draw it as well. Now, after the Snowden revelations in the summer of 2013, we had this nearly year-long period of intense global and domestic scrutiny and criticism of US espionage activity because so much was thrown into the spotlight. And frankly, people who don't normally follow the stuff somehow were very surprised to learn what it was NSA is capable of doing and what sorts of things it does do. Some of the things it did were surprising even to those of us who do follow this stuff. But on the whole, the point is that there was a wave of criticism. And you may recall that President Obama famously went out to NSA finally in the end and gave a talk where he rolled out a number of policy initiatives that were largely designed to tamp down, especially allied concerns about how much the United States was taking advantage of its remarkable hacking and other signals intelligence gathering capacities. And in doing so, one of the things he said was that we use these capacities only for certain purposes, and we do not use them for private commercial gain. There was a caveat, there was a footnote that said, that doesn't mean we would never spy on a foreign company. There may be any number of reasons to do that. I'm paraphrasing here, but for example, you might spy on Huawei because you need to understand to what extent is Huawei in fact acting as an agent or arm of the Ministry of State Security or the PLA, et cetera. This divide fed directly into the Obama-Xi negotiation that we talked about in the first lecture, where it seemed that the Chinese signed up publicly to a principle that they shouldn't engage in this sort of activity. They didn't acknowledge that they previously engaged in it, but they seemed to subscribe to the principle, and that was touted as a pretty substantial victory. But as we noted earlier, the amount of activity, which did drop off for a while, eventually came back, and it seems that in fact China definitely has not, notwithstanding that agreement, has not accepted this distinction. So under the general heading of espionage, if you're trying to figure out where are the policy divides that matter, that's the big one. There are also legal aspects to this, of course, and this is probably a time to stop and talk about the legal architecture, both in US domestic law and in international law, as it pertains to espionage generally, but it matters to us because it certainly then applies to cyber activity. So let me give you a quick sort of nutshell overview of this. With US law first, let's start there. This legal framework wasn't created in order to regulate cyber activity as such. The bulk of what U.S. law has to say about intelligence collection is directed at things that impact the domestic United States. So if you're targeting a U.S. person, if you are acting within the United States to carry out the collection, we have these incredibly elaborate, hotly contested, and often controversial sets of laws. You no doubt have heard of the Foreign Intelligence Surveillance Act, FISA. There are any number of complexities. I'm not going to go into all that because really here I'm trying to focus on the other stuff where it's foreign directed, the target's overseas, the collection's taking place overseas, et cetera. And there, in that vast realm of traditional foreign intelligence electronic activity, there's very little law. We do not try to, Congress does not purport to give the president the power to engage in this activity. It's fairly widely accepted that the president inherently, as a constitutional matter, has the authority to engage in espionage or to order parts of the executive branch to do so. What we've done instead is to set out procedural safeguards and oversight that are designed to create good incentives to ensure that there's a sense on the part of the executive branch that someone outside the executive branch, if only the intelligence committees in Congress, will be apprised, reliably will be apprised of what we're doing. And if there's something really stupid or untoward going on, that's going to be a problem. And therefore, some amount of hopefully self-checking against bad ideas will take place. So in short, what we've got under this heading is an oversight framework. Collection activity that is significant must be reported to Congress. Beyond that, we don't actually regulate it much. And so one might say, like, what about international law? Maybe international law is where all the rules come in. Indeed, isn't hacking, isn't all of this a violation of international law? Well, you know, you're going to get a difference of opinion about that because, of course, you can always get a difference of opinion when it comes to international law and matters of state and where the lines are. But I would contend, and Matt, I'll be very interested to see if you agree with this. Certainly the majority opinion amongst U.S. practitioners of international law, U.S. international lawyers, is that it is not a violation of a rule of international law to engage in foreign intelligence collection per se, to steal secrets as spies do. It is always, I think, always a violation of the domestic law of the other country. If Russia steals our secrets, it violates our law. When we steal their secrets, it violates their law. But it's certainly not a violation of the UN Charter as such. It's not a, as we'll talk about in a minute, it's not a use of force. It's not an armed attack. Is it at least a violation of some more nebulous principle of sovereignty? Well, in a minute, we'll talk about these more nebulous ideas below the level of use of force and armed attack. For now, I'll simply say that there are those who argue that there's a sovereignty principle that is violated by espionage. And that is definitely not the US government's perspective, is my impression. And I think that that's not the impression of the vast numbers of countries that affirmatively engage in and don't deny that in general, they engage in espionage activity. So I think international law has relatively little bite there, unless you add something to the fact pattern and you stipulate that the particular means by which some countries engaging in espionage involves some very unique and special element that in and of itself presents a different international law question.
Yeah, Bobby, I'll just jump in and say I agree with that take. You know, I think in answer to the question, is espionage legal under international law? There are usually sort of three answers: yes, no, or maybe. I think the best answer is that yes, it's legal, and the very short version as to why is because it's something that states have been doing forever, and there's no clear prohibition of it. States often, when they catch others in the act, will complain about it. So I might call it sort of legal but impolite as a matter of international law and diplomacy. But there is no international law prohibition.
Yeah.
Cyber espionage is interesting. In my view, there isn't a sort of special law of cyber espionage, but cyber espionage is different from classic espionage in a couple of ways. It's often much cheaper to do. It can often be done at a much greater scale. The OPM hack of the kind that you described before is a perfect example. You know, the number of records or the sheer amount of data that can be siphoned off by a successful operation is just much greater. So there's perhaps some reason why international lawyers and policymakers might be more concerned about cyber espionage than classic espionage. But I don't think as an international law matter, it's different. That actually raises another closely related issue that I was going to ask about. Some audience members have asked about this, which is foreign election interference, something that's gotten a lot of attention, or foreign political interference, disinformation operations. Many US officials, for example, have complained about Russian interference in American politics by injecting into the sort of information stream through social media false information or stories that are designed to sow discord, perhaps even efforts to try to sway elections or to undermine public confidence in elections. I think it's telling that when US officials have complained about Russian or other foreign interference in American politics, they don't generally claim specifically that it violated international law. They complain about it, but they don't say that it's a violation of international law. So is it a violation of international law? My view on this is that as a general matter, no, sort of for the same reason that espionage is not illegal as a matter of international law. Messing around in foreign politics, including things like propaganda operations, are pretty widespread. There are also things that the US government has its own history of doing. In saying that, I'm not trying to draw moral equivalency between US actions and those of some of our adversaries when it comes to information operations. But I do think it is very difficult to draw any sort of principled legal line that would make Russian information operations of the kind that we've seen in recent years illegal as a matter of international law, while allowing our own information operations, propaganda operations, efforts to even overtly influence foreign politics legal.
So I would mostly agree with that, but I want to introduce a complication. Under the general heading of election interference, there's a broad spectrum of intensity that runs from pretty modest, maybe even feckless efforts to impact the information environment when propaganda when an election's happening, all the way down the spectrum towards out and out digitally changing the vote. And I think as you get down that spectrum of intensity, you begin more and more to get into an area where you can actually indeed make an argument that there is an international law prohibition, at least when you start actually changing votes. And perhaps it's some stages prior to that even. Now, I don't mean to say that, I'm not saying that's an armed attack or a use of force. Rather, I think it's an internationally wrongful act in that it goes into what the scholars would call the domain reserve, a coercive intervention into the domain reserve of a state, which is a fancy and not very illuminating way of saying that in general, sovereignty is merely an underlying principle, not a sort of cast iron rule of international law as such, but there are a few elements of sovereignty that are so central to the state's identity and sovereignty itself, such as the election itself, that any foreign interference with that, though not violating a treaty-based provision in the UN Charter, could be said, and routinely is said by international law types, to be a violation of a customary international principle of sovereignty in that very specific and narrow sense. Now, one might then say, like, well, okay, so what follows from that? The idea is that if you have an internationally wrongful act that is a coercive intervention of that kind, if it's in that little narrow category, that triggers the international right of countermeasures. That is, the state can respond in kind with proportional measures that otherwise would not have been legally available to them, insofar as what they're doing is trying to stop the intervention. What follows from that? Well, what follows from that is that if, and this is a big if, you have a society that actually cares what the international law restraints might be, and I would say that whatever our limits are in that capacity, we care a whole lot more than Russia and China. If you have a country that cares and wants to take some action but can't because they deem it to be, it would be a coercive intervention, then if someone else engages in a coercive intervention, you've now got the ability to go to that same level, that same proportion. On the other hand, if what the other side is doing that is so unwelcome, the adversarial activity falls below that threshold, it doesn't mean you can't respond at all. It just means you can't respond in a way that would itself be unlawful. But by definition, apparently you can do exactly what they're doing to you, since by stipulation, what they're doing is below that level. You know, here's the thing though about all this. I should have led with this. With one other thing, you know, you mentioned, Matt, how cyber is a little bit different in various ways. Another way it's different is the greater extent to which it's not clear ex ante what it is that the adversary is up to once they've penetrated your system. Penetrating, at least for systems that may be relevant both for espionage but also for causing effects, at least those systems, when you can detect someone guiding your system, it doesn't always come with a calling card making clear what the intentions and prospects are for what's going to be done by the adversary with those accessees. Are they in the system because they're trying to steal a bunch of information in a classic espionage sense? Or are they preparing to delete all the files and cause a tremendous disruptive effect? Is information being stolen from a bank for intelligence purposes, or maybe commercial espionage purposes, or is it prelude to a digital financial sector Pearl Harbor? The indeterminacy that's inherent in the nature of the digital intrusion itself has some analogs, including especially with human assets, where maybe they're stealing something, maybe they're gonna break something. So it's not entirely unprecedented, but it's more ubiquitous and more confounding in this space. And that adds to the sense that you may not know how to categorize what you're dealing with and therefore determine the legality of it unless and until some further action takes place, or you have extraneous intelligence, maybe human intelligence, that gives you more fulsome of a picture. Now I'll say this, so we've been talking all along here about law. What about norms? You hear a lot about cyber norms, and there, in fact, I'll confess, it kind of drives me nuts. You hear so much discussion, oh, we need to build the norms in this place. What does this mean? That's not a legal category. It's by definition, in fact, if you're going to be formal about it, by definition, a claim that something's not a law in international law. It's not a rule of international law, but rather it's a sort of a best practice. It's a red line that, as a matter of policy, states are gravitating towards, something like that. It's what I would say the listeners should think of norms as. Norms are attempts to bring diplomatic pressure, moral suasion, pressure from your own allies, public pressures to bear in ways that might help encourage or forbid activity that the law itself does not actually yet reach. So if you can't get international agreement about where the red lines are in cyberspace, maybe we can at least get norms, because by definition, they're not as binding. Here, the same caveat applies, perhaps even more so than with regular international law, which is that the United States and other rule of law societies will necessarily be far more constrained, even if not that constrained, but they'll be relatively far more constrained than non-rule of law societies. And to a certain extent, that puts us in a trap, because we want to be able to engage in norm building. And norm building can progress into something even stronger. And this can be very valuable to us. Being a rule of law society, that means something to us. But at the same time, we shouldn't have any illusions about how the relative impact is going to be for us and for our adversaries. And therefore, we need to be a little bit wary when we see our adversaries advancing norm building projects, let alone treaty type projects relating to cyber activities, because there's very little reason to think that those projects will result in a major change in their behavior. There's real reason to think it would change ours. Moving on kind of quickly through the remainder, let's get to the questions. What about engaging in the cyber domain in the context of an armed conflict? We don't need to go too far in the details here, because I think it's actually at a certain level sort of straightforward. yes, international law, including the law of armed conflict, of course, applies when armed conflict otherwise exists and activities taking place in the cyber domain. There are lots of interesting questions, and here you see an image of the original, the Talon Manual, a famous scholarly effort to describe how international law best applies in this setting. Lots of interesting debates to be had there, lots of complexities because you get a lot of dual use civilian and military use systems that may be desirable to disrupt, yet there could be spillover effects on civilians here. But these are all just versions of familiar debates from the kinetic space when it comes to the challenges of applying international law. Slightly more interesting and also heavily trod ground is, well, what about the jus ad bellum, the international law rules on resort to war in the first place, or the use of force? There have been a million articles written about what it would take for a cyber attack, as it were, to count as a real armed attack for purposes of the UN Charter, or to count as a use of force for UN Charter purposes. It's not those aren't interesting. They're fun to discuss and debate. The shorthand version of this is that certainly you shouldn't indulge in any formalities and say, well, cyber is different, so that can never count. Well, of course it can count. Depends on what the effect is. It depends on what's being done and what's the context. If there's a cyber means of causing mass casualties or the destruction of an economy in one fell swoop, the sorts of things as a matter of strategic and policy judgment, the national government is going to view as a cause for war, and would have treated clearly as an armed attack or use of force if conducted with physical means, then there's at least a good chance the same sorts of judgments will be made in this setting. Much more interesting is to go on to statecraft that's below that threshold, or at least isn't clearly above that threshold, and to talk about how, whether acting covertly or overtly, how states, for want of a better phrase, how states screw with each other, not for espionage purposes, but to cause effects. And whether it's cost imposition or being disruptive or otherwise advancing their national interest, how states engage in operations for effect in cyberspace that are not about solving crimes for law enforcement or just stealing secrets, but for other purposes. Let me talk here
Bobby,
first.
can I just jump in? Just jump in, because I wanted to go back to what you said about the law of armed conflict and some of the UN Charter issues, and just to amplify a couple of points there, because it's, you know, it is sometimes said that, you know, cybersecurity and cyber attacks is this sort of ungoverned space as a matter of international law, and I think that's mistaken, because there is very broad agreement internationally that the UN Charter applies in cyberspace. There is widespread agreement that the law of armed conflict, or sometimes referred to as international humanitarian law, applies in cyberspace. So there's great agreement about some existing legal frameworks that have long held and have worked reasonably well in physical space. There's wide agreement that those apply in cyberspace. Now, there are big uncertainties about what those terms mean in cyberspace, how exactly those existing rules apply in the kind of fact patterns that we've been talking about here. And I would just say that, you know, I think there's going to be a limit to how precisely we can reach some agreement on those anytime soon, because the way international law ends up getting interpreted, the way those questions get answered, is often through practice. And it's going to take a while to, I think, work out some of the details of what those frameworks mean. States are reluctant to even figure out internally within their government what these terms, what these rules exactly mean, if they don't have to, if they're not presented with a real world case. States also want to maintain some freedom of action, some flexibility in their interpretation until they figure out how are these technological developments going to cash out? How are our vulnerabilities, our threats, our power going to change in relation to new developments in technology? So there's a limit, I think, for a while. For the foreseeable future, we're going to be in a situation where I think there's wide agreement on some basic legal frameworks, but a lot of disagreement or lack of clarity about what exactly those rules mean, how exactly they apply to specific fact patterns in cyberspace. I just make one final point on that, which is that I think those who complain about the lack of clarity of international law in cyberspace sometimes exaggerate the degree to which law is clear in physical space.
Exactly.
Right? The UN Charter, the text is clear. The text of the Geneva Conventions is clear, but there's still a lot of uncertainty and debate about what those rules mean in relation to specific facts and new kinds of threats. When do states have a right to use force in self-defense? What constitutes an armed attack of the sort for which states can use military force in response? Think about American counterterrorism strikes or U.S. strikes against Iran in the last year. These generated huge international debate about what Article 51 of the UN Charter means. When the law of armed conflict draws a distinction between military and civilian targets, that's a very difficult idea to apply to infrastructure that can be used by both military and civilians. Or how do we think about when the effects of an attack cause illegally disproportionate harm to civilians? These are very familiar legal rules, very familiar frameworks, but the answers, even in physical space, to those questions is difficult. So it's not very surprising that figuring out the answers in cyberspace would also be very difficult.
Boy, that's so right. And you actually made me think about one further point in this space. So I think about how the United States and coalition partners engaged in all sorts of cyber operations in the armed conflict with the Islamic State that were designed to take down their communication nodes, to locate them, to prevent recruitment, all sorts of things. We can just imagine, let's just hypothesize that in some instances, the Islamic State controlled server might not have been in Syria. And what if it's in some neutral or some third country's territorial jurisdiction? That's where that server happens to be, and no one there particularly understands or knows it. Now, if it's a country that's one of the coalition partners or on good terms with the coalition partners, it ought to be possible to work cooperatively with that government to take down the site. But what if it's not in a place that will cooperate? Or what if for some reason time is of the essence to where there is absolutely no time to take that action? And so what if, as part of the armed conflict, there's a felt necessity to take a cyber action that has operational effect outside the theater of operations? Now you're back to these questions about sovereignty protections in international law. Obviously, there are diplomatic and policy-based considerations too, but just from a legal perspective, if what we imagine is going on is unauthorized accessing of that server and then maybe bricking the server or doing something to alter it and have an effect, you're having an effect in the territory of a third party without even their knowledge, probably. Is it an armed attack? Is it a use of force? I think not. And so we come back to that question of, is it a violation of some legally, formally existing rule of sovereignty? Because in sort of a loose foundational sense, sure, it's intervening in their sovereign territory, so it's some kind of problem. But is it an international law violation? And again, we come back to that question that people disagree about so sharply in international law circles. There are a lot of people who would say, absolutely it is. If you go in and change data on a server in the United States without our consent, without the US government's consent, then you have crossed a line. And then there are others who would say, no. It depends on what the effect of what you're doing is and the importance of the system. And if what you did was to alter the election ballot counting software and delete the data there, yeah, that's a violation of the domain reserve. But if it's just some commercial provider, you know, it's some sort of Rackspace type cloud storage that the Islamic State was using. It's a diplomatic problem, but it's not an international law problem. This is a really live and difficult question. It's understandable. Other countries don't want the United States. They don't want NSA or Cybercom or the Five Eyes roaming their systems any more than they have to. And they certainly don't want them altering data or causing effects on their systems. So it's probably more of a diplomatic than a legal problem, but that's really what they fight over. And there are plenty of people that say, like, that's just the American perspective. It's not a legal problem. We say it is a legal problem. And that arises even when you've got an armed conflict, which is why the event's taking place. It's just the conflict is elsewhere. If we go back to this idea that there's stuff that goes on, that most of the stuff that we pay attention to that goes on, the real daily action that leads the newspapers and the websites to talk about cyber war this, cyber war that, cyber Cold War, most of this stuff is statecraft below the level of armed conflict. Often it's, formally speaking, covert action in that the government doing it is not willing to acknowledge it was them. Other times, it's not covert in that sense. It's just, you know, they're trying not to be detected that it's happening, but it's not something that people will deny they're responsible for. Either way, let me begin my discussion of this by emphasizing a really critical point about the difference between the categories of activity and categories of institution and how they don't have to align. These days, a lot of the activity the United States may engage in this space that is below the level of armed conflict and may be meant to occur in a way where the US role is not meant to be acknowledged, is conducted by the US military through cybercom, which to some people will sound wrong, like a mismatch. Shouldn't it just be CIA that does that? Aren't you describing just a cyber application of covert action? Well, CIA can and does do this sort of thing, but there's nothing that prevents the military from doing it as well if they're otherwise properly charged with the mission, et cetera, and it's otherwise lawful. So I'm going to begin the discussion by talking about the Defense Department's cyber strategy and the sorts of things that these days we not only insiders kind of expect Cybercom to be doing, but Congress is all but demanding that Cybercom do through legislation, no less. So the best entry point into this is to look at the 2018 cyber strategy of the Defense Department, which is summarized and quoted from here, where it said, "We will defend forward." That's the key phrase. "We will defend forward to disrupt or halt malicious cyber activity at its source, including activity that falls below the level of armed conflict." Remember earlier I said there's defense, there's deterrence, and there's disruption. This is disruption. The idea is that it's not just that we're going to defend ourselves, both private and public sector activities. It's not just that we're going to try to deter people by having scary cost imposition mechanisms. It's that now, unlike in the past, we are going to more assertively go out into the adversary's own systems, into what would be called red space instead of our own systems, blue space. We're going to go into red space. We will penetrate their systems without authorization, of course. And to the extent appropriate, we will actually operate on those systems for effect. We're not just going to steal information. We're not just going to engage in intelligence collection and espionage. We're going to disrupt operations at the source so that we don't end up having to defend them ultimately downrange in our own systems. This is usually summarized as the defending forward or defend forward strategy. And not surprisingly, it makes many people very nervous. It sounds kind of cowboy, right? It sounds like, oh, the United States is going to just go out there and say that they can go anywhere, do anything. And of course, that's not what we're saying. We're saying we'll go where it's lawful to go. Well, hold on, what kind of constraint is that? We just got through saying that there aren't very many international law constraints here in terms of penetrating other systems. Right, this is why people get pretty nervous. There's a question here about US domestic law, especially war powers in the Constitution. I'm going to just fly through this really briefly. I don't want to bog down on it. Suffice to say that if we're talking here by stipulation about activities that are below the level of armed conflict, it's really pretty clear that this is below the sort of classic war powers, separation of powers debate, where we say sometimes that certain actions shouldn't be conducted by the military unless there's an authorization for use of military force. If you're interested, the next slide or two will flag for you some of the key recent kinetic space legal thinking that the government's engaged in about what triggers that war powers debate. There's a quote here, I'm not going to read it to you, that talks about this idea that, you know, it's really only war in the war power sense if personnel are at risk. And right away, you can see that a purely cyber activity, very unlikely to trigger that concern. Of course, the Constitution is not the only question. We do have the War Powers Resolution, but the War Powers Resolution presents an almost identical version of the same threshold. The trigger in the statute of the War Powers Resolution talks about hostilities. If we have standalone cyber activity, then not surprisingly, the same sorts of narrow interpretations of what counts as war tend to be mapped onto what counts as hostilities. And even if one thought that certain cybercom defend forward activities perhaps nonetheless really ought to be viewed as requiring statutory authorization, well, now we've got, at least in some cases, a really explicit, almost like a mini AUMF, if you will, for this. The National Defense Authorization Act for fiscal year 2019 was the culmination of many years of Senate Armed Services Committee and House Armed Services Committee frustration with the relatively passive role being played by military cyber operators, and an attempt to make it crystal clear that they are permitted to operate in red space, at least in certain circumstances, whereas otherwise, without this legislation, maybe someone would argue that this is too close to the line of war powers. You need statutory authority to do it. So the idea here was to eliminate debate. I just suggested to you that that debate probably favored allowing the activity anyways, but this was to eliminate the debate. How did it do so? Express authority was given to Cybercom, specifically to Cyber Command, to take appropriate and proportional action in foreign cyberspace to disrupt, defeat, and deter such attacks. What attacks? Well, these attacks. Anything that is an active, systematic, and ongoing campaign of attacks against the government or people of the United States in cyberspace, including attempts to influence our elections and democratic political processes. You see, of course, that they're reacting here to the 2016 election, and it's also some signaling here to adversaries that there is no doubt in our system that Cybercom is affirmatively charged, notwithstanding any legal constraints that otherwise might apply, to go out and affirmatively operate in adversary systems to prevent this sort of thing. And then there's a second element. There must be one of the four major adversaries that are always cited these days: Russia, China, North Korea, or Iran in the fact pattern. To summarize then, Congress has pre-approved and eliminated all doubt that Cybercom is supposed to get into Russian, Chinese, North Korean, and Iranian systems insofar as it is necessary to cause effects there that will preempt, or that's a loaded word, let's not use it, that will disrupt at the source systematic cyber attacks against US or American national interest in cyberspace. Again, I think that authority was implicitly there already, as long as it was below the threshold of war. But now there's no doubt, at least as to that scenario. Now we should wrap up here by comparing this to covert action and making sure we understand, given that this stuff can look just like traditional covert action, and covert action has to be subjected to some pretty serious legal constraints, what happens with the military? Well, in the covert action setting, we require by statute a presidential written finding authorizing the action, which means the White House has to really own it, which has a certain checking effect. And it has to be reported after the fact to the select committees on intelligence in the House and Senate, which has a little post hoc accountability too. For these military activities in cyberspace, which, let's be clear, can be deniable, we've built up a sort of parallel system over time. In 2013, Congress started requiring quarterly operational briefings to Congress. Not quite the same thing as immediate operation-specific covert action reporting, of course. So what else? In 2017, we created a pretty parallel system. The Secretary of Defense, not the President, but the Secretary of Defense has to give a written notice to Congress the armed services committees, not the intelligence committees, each time you have an operation intended to have an impact in a foreign location, like what I described a moment ago with a third country being impacted, within 48 hours. So I would argue that something pretty analogous does now exist. It's just not quite the same thing because the president's not personally involved. And we can discuss in the Q&A now whether, who does make the decisions on this. But I think at this point, we should stop here, Matt, and close out with some questions rather than, a couple of not that interesting final slides.
No, that's great. We've covered a lot of ground. And so in our remaining minutes, let me just ask a final question, which is, you've talked about the way in which law is relevant or helps figure out which branch of government gets to engage in offensive cyber activities. Then one of the things, having decided that the executive branch has a lot of power in that area, the law helps assign some responsibilities between the military and the intelligence agencies. What about at what level? How high up does approval have to take place? Because that's another function that law can play, is mandating that only the president can authorize certain actions. If you were really concerned about the possibility of inadvertent escalation or something like that, you might want to make sure that you had the very highest level of sign-off. On the other hand, if you want to engage in a lot more cyber activity, you might delegate authority to launch operations to lower levels in that hierarchy. What's been the debate about this in American law? What kind of moves have taken place to try to get that right? That idea of how high a level the approval has to take place.
I hate to say it, but possibly the best public source now available might turn out to be John Bolton's book, but I don't know if I can encourage people to go buy that or not. Let me just say this, that in the Obama administration, it was well recognized how escalatory and potentially strategically significant unanticipated consequences in this space could be. And so there was an executive order directive framework that required interagency vetting at the White House level for at least a substantial chunk of the more, shall we say, impactful types of overseas cyber activities we might engage in, for all these reasons you just said. And this meant that State Department, intelligence community, and others would have some say as to whether to go forward, or at least have a good window to raise objections to what DoD might otherwise be inclined to go do. And so you had some potential for friction there, and that's the whole point, right? Is some of that friction is needed because different institutions will have different interests that they weigh differently. And maybe the best way to get to the overall national interest is to ensure that you hear from all of them. But on the other hand, it, by definition, also at the margins will reduce the number of activities you engage in. It'll cause some things not to occur. We've known for a long time that the Trump administration changed that policy in some fashion that had the general tendency to push down into just DoD the bulk of the authority. And it looks like from an outside perspective, and I don't have any access to the classified information, and it's not actually public what the details are, but it looks like Cybercom has a considerable amount of discretion. There may be some degrees of DoD oversight above that. I've been told by people who would know that there are still less formal ways in which the other agencies have awareness of what's going on, have some degree of sign-off, have an ability to throw red flags or throw yellow flags, as the case may be. But there's no question that this directive, National Security Presidential Memorandum 13, which Bolton does apparently talk about in his book, and SPM 13 does try to make the military more nimble and agile and operational. And I got to say, on the whole, as long as there is some way for the other agencies to have their equities voiced at some level, I think this is a good development, because the legislative development, that directive, all these things that enable Cybercom to play a more effective role in red space doing disruption operations, it answers the central strategic question you posed earlier, which is, what do we do if deterrence isn't working and defense isn't enough? And if we're being judicious in where we're using these more aggressive, go out of your own network, go into the foreign network and disrupt capabilities, if we're doing this carefully and thoughtfully vis-a-vis the right adversaries for the right reasons, I'm afraid that's exactly where we need to be, at least for the time being.
That's a great note to end on. Bobby, I want to thank you for 2 great talks today. Thanks for running through so much material with us, and thank you all for participating.